We'll start by calling Boone County criminal case CR 2015-91, State of Arkansas versus Carrie Fouch, F-O-U-T-C-H.
Your Honor, she's applied for the services of the public defender.
Your Honor, Mr. Russo called me early this morning about her, and she had turned herself into the jail, so neither one of us are actually familiar with the charges other than it's a hot check case. So if I could borrow the file for a second.
Your Honor, I had a discussion with my client. She became aware of charges in Arkansas. She's got charges pending in Baxter County here and in Carroll County, and upon discovery of those, drove straight down here and turned herself in. What I'd asked the court, since she's taken the initiative to try to get this cleared up on her own, I was going to ask the court to consider releasing her on her own recognizance. She's still going to be held on bond on the other agencies, and that will allow her to be released to go over to those other jurisdictions and get those squared away.
Your Honor, these checks total $1,200. I'm not opposed, certainly, to a reasonable bond. I can't agree to a strict OR bond, but if the court reduces her bond to either $1,500 or $1,500 signature bond, the state would be satisfied given the circumstances as the state understands them at this point.
The bond is already set at $1,500.
Judge, if the court would consider releasing her on a $1,500 signature bond, I think it says a lot. She drove down from Springfield and turned herself in on this charge.
You know, the problem with that is, and I agree with you in most respects, the problem with that is that if she lives in Springfield, she's out of state, and we don't really have any bondsman on a signature bond to call upon to get her back if that became necessary.
Yeah, Your Honor, may Mr. Carter and I approach?
Certainly.
Judge, in talking with my client, she was in an abusive relationship. She's got 2 children, and one of the things that she did is she got her kids placed with family members, made up her mind that she was getting out of it once and for all, put her kids in a safe place, and came down here and talking with her where she's going to go if she's released is to one of the women's shelters, either here in Harrison or Serenity over in Baxter, and trying to get her life put back together. She doesn't have any plans on leaving the state. We can make that as a condition of law. She can't leave the state of Arkansas. And as like I told Chris, I think the women's shelter are going to help her get back on track.
Based on the information the court has been furnished, the court's going to grant the request for a signature bond. It'll be a signature bond conditioned upon the defendant not leaving the state.
Thank you, Your Honor. Carrie, as we talked, I explained to the court what your plans were about living arrangements here in Arkansas. So you're going to be able to do a signature bond, but you can't leave the state of Arkansas.
Okay. I take it she's entering a plea of not guilty?
Yes, Your Honor.
This case is on the Division 3 docket of Judge Putman. I'll set her to reappear in front of Judge Putman on June 26th for reappearance.
So your next court date is going to be here at the courthouse in Boone County on June 26th.
Court calls 2011-202 State of Arkansas versus Lawrence Brown. This is a first appearance on a petition to revoke that was filed June 3rd of 2015. The allegations contained in the petition to revoke are that Mr. Brown has been arrested for driving on a suspended license, no seatbelt, speeding, no proof of liability insurance, and other misdemeanors. which is a violation of the condition that he not break the law. It's also been, that dates from August 8th of 2014, from October 21st. It's alleged that he failed to appear in court, and that's a misdemeanor. And from May 15th, 2015, it's alleged that he was a felon in possession of a firearm, committed that offense. All of those are violations of the condition that he not violate the law. It's also alleged that on October 7th of 2014, that he committed the offense of having possession of, or having a positive urinalysis indicating the use of marijuana, and also that he violated the condition with respect to possession of a firearm, and finally that he has failed to pay court costs, fines, and fees. There are allegations associated with each of the other allegations in that regard. The dates of those that have been provided previously. Mr. Brown, you're appearing here today for arraignment. Here's court is making the appointment of the Public Defender's Office to represent Mr. Brown. On the allegations that I've read off contained in the petition to revoke, how does the defendant now?
Not true, Your Honor.
It's a brand new case.
This case is on the Division 4 docket. I'm going to set it down for well, I'll set it for June 19th.
And I'm sorry, Judge, what day was that?
June 19th.
Your Honor, I'd ask that
For a hearing.
I'd ask that a reasonable bond be set in this matter.
Judge, in looking at his 8.1, it appears Judge Kirkpatrick set his bond at $7,500. Given the number of times that Mr. Brown has appeared in district court over the past couple of years, Judge Kirkpatrick, I'm sure, is familiar with this man and felt that even though this court set a no bond, felt the $7,500 bond was reasonable.
Your Honor, I believe the $7,500 bond was actually his arrest for being a felon in possession. It wasn't for the revocation. I asked this court to set a reasonable bond that goes concurrent in both cases. Your Honor, he's been a resident here, and as my colleague so eloquently put, he's familiar with the district court. He shows up to court. He's not a flight risk.
He does have a failure to appear from October of 2014.
He's here now, Judge. And as such, I'd ask the court to set a $2,500 to $3,500 bond in both cases.
I'm going to trust Judge Kirkpatrick's judgment. I'm setting it at $7,500
For both cases, Judge?
for both cases.
Thank you, Your Honor.
And his next appearance in court will be June 19th. So, Mr. Brown, if you bond out, you need to be back here in 2 weeks.
And
You
Judge,
may
that bond is cash or pro?
Cash or pro. And you'll need to be in touch, get in touch with the Public Defender's Office as soon as you're released on bond. If you're not released on bond, then I'm confident they'll be in touch with you. You may be excused. Court will call State of Arkansas versus Randy Ammons. Randy Ammons present?
He's not on my list, Your Honor.
I know. I'm calling a case for in court. Thank you very much.
Sorry about that.
No problem. Calling 2014-126 on a reappearance, that's State of Arkansas versus Eddie Criswell. We also have Mr. Criswell on a revocation, 2012-248.
Your Honor, on Mr. Criswell's case, we're calling the court's attention that the eval status was completed in one and not the other. We still don't have that issue resolved yet. So on the reappearance, the 2014-126, I think we're still in a holding pattern. And on the revocation, we do have it. However, we'd ask the court to allow us to get the eval situation squared away before we proceed.
Judge, we can proceed on the revocation now.
Is the defense accepting of the evaluation?
We are, Judge, but procedurally, I just don't want anything to come back at a later date.
What's the status of the evaluation in the new case?
Judge, we sent everything down for both cases. They did their evaluation. They sent it back with the information and the report only referencing the revocation case. We did send an email down to Billy Burris pointing out this fact. I strongly suspect that the evaluator has enough information there that they could write a report on the other case, which is what we had suggested to Mr. Burris. But in our view, that's about as far as the state can go. But like I said, we're prepared on the revocation.
My only concern, Judge, is just so that the record is clear, the court ordered the evaluations in both cases at the same time. I expect it's the same exact report because it was supposed to encompass both of them. However, when they sent the report back, it did not. I think it's a technicality, but it's a technicality that needs to be cleared up to perfect the record.
Yeah.
And Judge, I agree. In the 2014 case, very clearly, it needs to be cleared up because that case is in suspense until a report is filed. But the revocation case, we don't have a problem.
Well,
and one of the things, Judge, is one of the allegations in the revocation is on the basis of the new charge. I had anticipated doing a wrap-up with the new case, and if my client, if he was to enter a plea of guilty in the new case, that would take care of the revocation. Procedurally, we're not there, and that's my concern.
well, I'm going to agree with Mr. Russo on this. I think in terms of mental competency, I think the evaluations both have to be complete before we have a clean record on his mental status. What I want to find out is what does each of you think will take to get the Department of Mental Health to respond?
If Mr. Russo will call the psychiatrist or the examining person directly, that may potentially resolve it.
Your Honor, based upon my experience, especially when I was in the 16th District with the Public Defender's Office, what we wound up having to do over there is getting Judge Weaver or Judge Kemp to start doing show cause orders on Mr. Burris. And amazingly, in a short amount of time, we would have it fixed before the show cause hearing came up. I would propose a potential letter from the court or show cause order from the court to Mr. Burris asking that it be fixed. That seems to be the only thing that gets their attention.
But I think Mr. Burris likes me, so I don't want to send it to him. And there's not that many people that like me.
I'll stand up. I like it.
Oh, well.
When something shows up on a public defender letterhead, Judge, a lot of state agencies do not jump up and take notice.
That might include the prosecutors.
Exactly, Judge.
Well, I'm going to find that because the evaluation is not complete as to both cases, that the matter is still in suspension, even though Mr. Carter is pressing to go forward on the revocation case, that the 60-day requirement is being held in abeyance at this point in regard to that because of the incomplete evaluation. And I guess I will write a letter and try to get that done. I may need to be reminded, in light of the absence of my certified court manager, to get that letter out. But
Judge, on May 8th, the 60 days were waived, and I think we were aware of this situation on May 8th, so the 60 days, and I understand the court says the revocation is not back, but can the court also agree that the 60 days has been waived?
yeah, the court's going to, the record should reflect that the 60-day requirement is non-applicable until this evaluation is complete.
And Judge, I'll have our staff get with the court's case coordinator next week and let them know exactly what we need worded in the letter.
Do we have a reappearance date on 6/22? Do we think we can get this done in 3 weeks?
6/19?
Oh, 6/26.
No, 6/19.
Is that our day?
That's my next day.
Oh, okay.
We could set it for that day, Judge, and hopefully we'll have it done.
Let's see if we can't move this forward. All right, Mr. Criswell, we're trying to get all the evaluation paperwork done, and you'll be notified when it is. Your next day in court is scheduled for June 19th. All right? All right.
Plants, and more plants. That's what you'll find at Camps Plants in Harrison. Perennials, annuals, ferns, hanging baskets, shrubs, roses, and the largest selection of garden vegetables in the area. With different varieties arriving weekly, you're sure to find the perfect plant, shrub, or tree at the best price in the area. Camps Plants, in business for over 30 years in Harrison.
Liquidation Outlet in Harrison. What will you find today? Hi, this is Amy, and we have a big selection of bathroom supplies, including mainstays, faucets, shower caddies, shower heads, bathroom space savers, and a lot of miscellaneous plumbing supplies. Stop paying retail and head to Liquidation Outlet for great savings. If you miss a day, you miss a great deal. What will you find today at the Liquidation Outlet, just off the bypass in Harrison?
Best deals that you can get at the Liquidation Outlet.
Crystal clear mountain streams, river rapids, and rolling hills with endless valleys. The beauty of the Ozarks we often take for granted. At Magnus Toyota, we never underestimate the value of our customers. As a third-generation family-owned business, Magnus Toyota has been operating here in the Ozarks for over 50 years. When we make a new deal, we make a new friend. Stop in and visit us today and see why our customers say we're the best. Magnus Toyota, your hometown Toyota dealer on Highway 65 North in Harrison.
2015-94, State of Arkansas versus Taz Bibby. Mr. Bibby appeared on the 15th of May in front of Judge McCorkindale. He was arraigned, entered a plea of not guilty. and was a scheduling order has been entered that sets this matter for trial in September, pretrial also in September, and a reappearance date of August 14th. Is there another reason he's before the court today?
Your Honor, I think the only reason he was put off for today was because it was Judge McCorkindale, and I think just wanted to make sure that a scheduling order and counsel status were done. And my file reflects that we were appointed, and we do now have a scheduling order in place.
All right. Mr. Bibby, you may be excused, sir. We have Newton County case 2015-16, State of Arkansas versus Ryan Ray Lewis.
Your Honor, Mr. Lewis is a co-defendant that Mr. Bunch represents, and he had a conflict. As of May 8th, the file's been assigned to me. I have not met with my client yet. However, I would ask the court, we'll keep the existing scheduling order. I have my client make an appointment to come in and see me, and we could return on June 19th with whether or not I'll need a continuance, pre-trial, or something along those lines, Judge. But right now, I anticipate we could stay on track with the scheduling order.
Okay. Case is set for trial the week of July 6th. The pretrial is reset for June 19th. Now, you need to get in and see Mr. Russo and go over your case with him.
All right. Yes, sir.
All right.
Ryan, I'll get
You may
Monday
be
and make
excused.
a point to come in and see me.
2012-119, State of Arkansas versus Coy Cook. Is this matter for hearing?
I don't believe so, Your Honor. I talked to Mr. Russo, and I've talked to his probation officer.
Your Honor, Mr. Cook's case, he's prepared to admit his violations. I had a talk with his probation officer, and his probation has actually expired, but he still has costs that are due. My client has had numerous medical issues and has applied for disability. I'm asking the court to just allow him to be discharged, and that once he gets his disability, he can pay off the balance of what he owes. The state, it's my understanding, is wishing and asking the court to extend his probation. The only issue, Judge, is with my client having no income and having very limited means. It's my understanding that that would create an extreme financial hardship on my client. I can't guarantee my client that the state would waive his fees and costs, and that's where we're at.
No, we timely filed a petition, Your Honor, and so clearly we can revoke his probation because he has applied, and Mr. Cook certainly looks a lot better than he did last time, but I'm pretty sure that he's probably going to be placed on disability. I just want to have something in place to make sure that he is going to pay, other than at some point in the future we might file a contempt. I need to have something that is a bigger hammer hanging over his head.
Judge, I think a suspended imposition of sentence would achieve the same thing.
What's this?
That's from his officer, Your Honor.
Since then, I had a little discussion with his officer. And Judge, they're not necessarily opposed. We could have the order extending his probation for a period of 1 year, making this a condition. We can make it non-supervised probation. But the state believes the state just must have a hammer.
Is the petition we're working about the one filed in January of 2013?
I believe so, Your Honor.
Mr. Cook, are you at this time, are you prepared to enter a plea of true to the allegations contained in this petition to revoke that was filed on you?
Yes, sir.
Well,
Judge, may I approach?
certainly. All right. Mr. Cook, on the allegations that are contained in the petition to revoke that was filed against you, they include that you have failed to provide proof of employment, failed to notify a supervisory officer of change of address, that you left the state of Arkansas without the permission, excuse me, in violation of the terms and conditions of your probation, that there was times that you failed to report a particular month of January of 2013, that you failed to pay supervision fees, and at the time of filing the petition were behind on your supervision fees, failed to pay the restitution that had been ordered, failed to pay your fines, court costs and fees that were ordered, and failed to complete community service that was ordered. All of those are allegations contained in the petition. On those allegations, how do you now plead?
True.
You're entering this plea of true with an understanding of the proposed disposition of this case. You've discussed it with your attorney. Are you satisfied with the advice and representation that your attorney has provided you?
Yes.
Okay. It's important that you say words. I can understand your head nods, but the court reporter has to get your answers down, please. So you're entering this plea, are you entering this plea freely and voluntarily?
Yes.
Has anybody in any form or fashion forced you into entering this plea?
No.
In entering this plea, you understand that you're giving up or waiving a right that you would have to a hearing at which the state would have the burden of proving that you violated. At that hearing, you'd be entitled to be represented by an attorney and assisted by that attorney throughout. At that hearing, you'd be entitled to confront the witnesses that appeared, and you'd be also entitled to appeal. All of those are rights you're giving up by entering this plea today. Do you understand that?
Yes.
Based on those statements, the court and your statements that you are in fact in violation of the terms and conditions of your probation, the court at this time finds the defendant has freely and voluntarily entered his plea of guilty, done so after consulting an attorney, has acknowledged that he's in violation of the terms and conditions of probation, and at this time the court accepts the plea, finds the defendant in violation, and will order that his term of probation will be extended for 1 year. Be back on supervision for 1 year. Subject to that, the court is requiring that that he'll be relieved from formal supervision during this 1 year period, and not require supervision. He will have to stay in touch with the probation office and comply with all the other requirements, including the payment of the obligations that he still has outstanding with the Department of Community Corrections.
Yes,
all right? That'll be the order of the court.
Thank you, Your Honor.
You may be excused at this time.
Hi, this is Jim Fitzgerald of Community First Bank, and we have a variety of home loan options that are sure to fit your financial needs. From 100% financing rural development loans to VA loans for veterans to FHA loans with low down payment options, your locally owned hometown bank has the right home loan for you. Community First Bank, where it's all about community. Member FDIC and an equal housing lender.
Dental Creations on the Square in Harrison is the go-to place for all your denture services. We know how to get good results. We save you time and money because our lab is on site. A dental office you will like and trust. Dental Creations on the Square in Harrison, next to Harness Boots. Just look for the big red boot next door. Call today. You'll be glad you did.
Arkansas Orthopedics and Sports Medicine now offers you 2 orthopedic surgeons, both trained in all the latest surgical techniques. Dr. Sedani and Dr. Cutler specialize in all forms of orthopedic problems and injuries, from torn rotator cuffs to joint replacement, even sprains or broken bones. Dr. Sedani and Dr. Cutler will see you quickly and with the highest standard of efficiency. The entire staff of Arkansas Orthopedics works to keep you moving. Call today for an appointment. Call Dr. Sedani and Dr. Cutler in Harrison at 741-8289.
Now what?
Let's go. That way.
Have fun out there on the compact, capable, and entirely new Pioneer 500 from Honda.
Come see us at 824 North Main in Harrison.
Purposes of changing your plea on the charges in this case?
Yes.
You need to speak up so the court reporter can hear you.
Yes, sir.
And this change of plea is brought about by, after discussion with your attorney, Mr. Russo?
Yes, sir.
And has he explained to you the process? It's similar to what you may have just witnessed in the previous individual entering a plea and then hearing argument from both sides with regard to the appropriate disposition of your case.
Yes, sir.
And, are you prepared to enter such a plea?
Yes, sir.
You understand that when you plead directly to the court like that, basically you're allowed, you turn it over to the court to make a decision based on the that is a decision and impose sanctions up to and including all of the the full range of possible penalties. You understand that?
Yes, sir.
Are you satisfied with the advice and representation you've had from Mr. Russo?
Yes, sir.
On the allegations contained in the petition, which I'm going to quickly review at this point, those allegations are that on or about February 26, 2015, you were arrested and charged with being a felon in possession of a firearm. That is, having previously been convicted of a felony, you were in possession of a firearm, and then possession of drug paraphernalia, which is a separate felony. That's in violation of the condition of your probation that requires you to abide by the law. The allegations also are that you had positive tests for controlled substances on January 6, 2015 and February 2, 2015.
Your Honor, my client's prepared to admit all the drug things, but the weapons were actually belonged to a family member, and those weapons were discovered in the family member's room, and my client was not charged as on those weapons. However,
that is correct. He was not charged. They were in the house, they were locked up, but they were in another person's bedroom, and so the state decided we would not pursue those charges.
but my client is admitting to the positive UAs and the possession of the drug paraphernalia.
So on the parts of the allegations that relate to the possession of drug paraphernalia, which charged as a felony, and the two positive tests for usage, how do you now plead?
Guilty.
Okay, so you're admitting you did that?
Yes.
All right. In entering this plea, you understand that you are giving up certain rights that you have. The primary right that you're giving up are the right to a hearing on a revocation. At that hearing, the state would have the burden of proving that you had violated. At that hearing, you'd be entitled to be represented by an attorney and have the attorney assist you in defending yourself. At that hearing, you'd have the right to confront the witnesses that the state called to testify against you. That's usually done by having the attorney that represents you cross-examine those people. And finally, you have a right to appeal. All of those are rights you're giving up by pleading true today. Do you understand that?
Yes, sir.
And understanding that, are you still willing to plead true today?
Yes, sir.
Are you pleading true here freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea of truth?
No, sir.
And you've already stated here on the record that you did that you did use the controlled substances and have in your possession the drug paraphernalia.
Yes, sir.
On that basis, the court's going to find that the defendant has freely and voluntarily entered his plea, done so after consulting an attorney, and has admitted that he violated the terms and conditions of probation. Therefore, the court's going to accept his plea, find that he's in violation, and at this time I'll hear argument on sentencing.
Your Honor, in light of his charges and in light of his violations, obviously my client has a drug problem, Your Honor, and what I'm asking the court to do is twofold. One, order that my client have to attend and complete the SAPL program through probation and parole, and two, that he have to report and fully comply with any and all terms of a evaluation through HRA, including any either outpatient or inpatient drug treatment that HRA should require as a result of that mental health screening.
Judge, I wanted him in on drug court. He doesn't accept that, so I'm going to recommend to the court 1 year in the regional punishment facility. Based upon the two prior cases and what the court now has before, this is a serious, long-lasting problem, and obviously outpatient is not working with this young man. So the treatment facilities that they have at the regional punishment facility we'll get him the help that he needs.
And Your Honor, my client would like to address the court.
All right.
I've been taking drug tests for the past almost a month or so. I passed all of them. I just did sample class. I went Wednesday to my first one, and I just want to continue doing sample class, and I've been doing good lately. I have a job. I work at Collins Heating and Cooling, been there for nearly 2 years, and I mean, I don't want to lose my job, and I'll lose my job if I do this and get sent away, and I don't want to lose that because it's hard to come by a job that you like doing, and I love working HVAC. That's what I love doing.
What is it you do there?
I do duct work. I install heating units, furnaces, cooling units, air conditioners. Do the wiring, do it all, duct work and all.
Judge, we discussed drug court, and it was my client's understanding, and I couldn't direct him otherwise. Because of the nature of his job and travel and where he goes, he felt that he would be setting himself up for failure because he wouldn't be able to meet the strict constrictures of drug court reporting, having to miss work, having to take off from work, things along those lines. And the only alternative I could think of and come up with is, and I explained to him that if he goes for HRA and they recommend inpatient treatment, he may miss 30, 60, 90 days of work if they recommend inpatient treatment. He understands that, and he feels that under those conditions his boss may consider giving his job back if he knows he went into inpatient treatment, came out, versus being called away as an aggravation to his employer. Since he has been clean, I don't think for sure that he would be ordered inpatient treatment, but he understands that's a risk he's taken if the court orders him to go to HRA and have that complete screening and have to abide by their recommendations. But he has had clean drug tests through his probation and parole officer, and he has now started sample classes.
Mr. Carter, do you have anything else you want to say?
Just given the long history, I believe Robert Young needs something much more intense than what has been recommended. And obviously, in my position, the most intense thing that I can recommend short of the regional punishment facility is drug court. But in order to go to drug court, you have to want to go to drug court, and Mr. Young does not. So that leaves me with no viable alternative than the regional punishment facility. And I will tell you, I talked to his probation officer. She strongly believes that drug court would be good for him.
Just with the class, it's not the drug issue I have with drug court, it's the classes and stuff that go with it that's going to interfere with my job. I don't have nothing. I will report and everything just like I have been and pass all the drug tests if I have to, 3 times a week. It's just the classes that go with drug court that I can't comply with.
When did you start your job?
Nearly 2 years ago. I've been steadily working, been doing good, and here lately I've changed. I had a change of life, and I feel that I can do this, and if you give me one more chance, I feel that I can do this.
What do you feel brought about your change in attitude?
My kids, they've become more important than any drug out there. I seen how I was living, my lifestyle. I wasn't getting anywhere. I wasn't making any gain. I have money in my pocket now. I learned to save and budget my money better, and I can go out to eat and do things that I want to do now. And without, I don't know, it's just, I just don't want to lose my job and stuff over this, and I just wish you'd consider one more chance, Your Honor.
All right. Well, what the court, I'm just going to say, the court's been fooled before.
Yes, sir.
Quite a few times, in fact. But you're saying some things that I think are meaningful to the court in terms of what works for some people in being successful in dealing with substance abuse. You should recognize that the prosecutor is actually recommending something that I feel very strongly is in your best interest. The program he's proposing to put you in is one of the best programs in the state. And both he and I have seen it work repeatedly with individuals who go through that program, particularly if they take it seriously and work the program. So I want to make sure it's clear that I'm not rejecting the prosecutor's recommendation, because it's basically what may very well be the best recommendation that's been made today. Ultimately, I'm going to give you a chance because I believe that a core ingredient in anybody being successful in dealing with substance abuse is that they have to believe in themselves and want to live a sober life and get the drugs out of their life. If you're sincere in what you're saying, if you're motivated by your children and desire to have a better life, and recognize that drugs are going to interfere with that, and you're being able to take care of your children, that tells me that you've got some priorities straightened out, and I'm impressed by that. And so it's basically on the basis of that I'm going to give you a chance to prove yourself wrong. Basically, I'm taking a chance based on what you've told me is important to you. And so what I will do is I'm finding you in violation. I'm going to continue you in probation. As I said, I've seriously considered the recommendation of the prosecutor, but I'm not going to impose that. I'm going to require you to remain active in the SAPL program within the Department of Arkansas Community Corrections, and take that program seriously. I'm also going to order that you be screened by HRA and abide by all of their recommendations in terms of any treatment that they recommend is needed. It's absolutely crucial to your being successful the rest of the way on your probation, that you pay attention to what's in your best interest, and what's in your best interest is just the things you said that have caused this change. If you are sincere about how much you like your job and are willing to continue to work on that, I think that more than anything in the world will help you continue to straighten your life out. And if you're so motivated as you've said here today, then I'm impressed with that and willing to take a chance and make that the order of the court, that you continue on supervision. Now, the thing that you have to do is make sure that you don't have any positive UAs from here on out. You need to understand that the next time you come down this road, you may not get the same recommendation from the prosecutor, and you may not get the same consideration from this court. This is this isn't, and this doesn't end today. It's up to you to make it work from here on out, and I'm giving you that chance, the chance you asked for. And just remember that if you end up back in court.
Yes, sir.
All right? That'll be the order of the court.
Thank you.
Books are an important part of your life, and when you go to Books on the Square, you'll find books that will not only be informative, but books that will take you away. Books on the Square now has 2 locations on the south side of the Harrison Square. Books on the Square carries fiction books, books on CD, lots of westerns, and books full of mystery. Books on the Square, too, next to Deb's Frames and Things, has your nonfiction favorites, religious, historical, and even cookbooks. Take a stroll down the south side of the square and visit both Books on the Square.
What's the first thing you notice when you walk into an Arvest?
When I come in and they call me by name.
Half of the people there call me Aunt Bliss.
Even the branches that I don't go in a lot, usually I get a greeting.
When you get off work, you want to see happy people.
They always say good morning or good afternoon.
They answer everything I need.
I enjoy seeing my family at Arvest at any time.
When I'm running late and you think you're not going to make it and those doors are still open here, it's a relief.
Arvest Bank. Our customers say it best.
Nature's Wonders has been the area's premier location for value and quality in vitamins and minerals since 1994. But that's only scratching the surface. Nature's Wonders also features products that are better for you and your family's everyday needs and are also better for the environment. Nature's Wonders selection of freshly grown organic vegetables and environmentally safe cleaners allow for a healthier heart and home. From the latest addition to the trusted friend, there's something for everyone at Nature's Wonders, your supermarket of healthy choices.
When you support a locally owned pharmacy, you're contributing to the growth of the community. The dollars you spend stay right here to support our local community. Health Mart pharmacies are locally owned pharmacies. There's one right here. Health Mart pharmacists have a personal commitment to their communities because, just like you, they support their community. Health Mart pharmacies are locally owned and hometown proud. Harrison is a Health Mart town. Sam Alexander Pharmacy on the square downtown. Health Mart, caring for you and about you.
We have 2013-168, State of Arkansas versus Amanda Christian.
Your Honor, Ms. Christian's case, I'm going to ask the court to set this out. We had set it over to today because there's apparently some new charges that are coming down, and it's my understanding she has not been yet served with those charges as of yet. I'd like to set this matter over to July, Your Honor.
And Judge, that's fine with me. Mr. Russo and I discussed a resolution that would encompass both of those.
The court, based on the defense request and an ongoing waiver of the 60-day requirement, this was down for review today only. So the court's going to grant the request, set it off for reappearance on July 31st and possibly whatever disposition by that day.
Thank you, Your Honor.
That'll be July 31st is your day to reappear. 2014-157 out of Boone County, State of Arkansas versus Randy Amons. My understanding he's just been served with this petition to revoke.
Do you have the petition?
No, Ms. Higgins grabbed me this court this morning,
2014.
and I said, I don't know who you are.
157. Court's going to find, or is going to appoint the public defender's office to represent him.
You didn't want to share that with me?
I thought you're the guy that signed it. Judge, I take it as a good sign the prosecutor has no idea when my client's here under probation revocation, so since my client voluntarily showed up, I'd ask that he voluntarily be released.
He voluntarily showed up because his probation officer asked him to be here so he could have it read to him. That much I know.
Okay. The court has, let's see, are these the same? Yeah.
TJ, is he yours?
Mr. Emmons, you're appearing here today on, as a result of the filing of a petition to revoke a suspended sentence. The allegations contained in the petition are that On May 7th, you failed to report your supervising officer for regular monthly visits. On May 28th, officers attempted a home visit and were not able to verify your home address or that you were there. On April 20th of 2015, that you had not been, the allegation you had not been truthful with the officer by not providing a way to contact him. On May 29th, it's alleged that you owed $70 in supervision fees that you had failed to pay. It's alleged further that on May 29th that you had failed to pay $721.91 in restitution payments and had not made a single payment towards this debt in the time on supervision. That it's alleged that on that same date that there was $1,490 owed on fines and court costs, and that you had not made one single payment. All of those are the allegations contained in the petition. On those allegations, how do you now plead?
Not true, Your Honor.
I'll note a plea of not true. This matter is before Judge Putman. I will set it down for hearing in front of Judge Putman on June 26, 2015. It's set for hearing.
See about getting a bond.
All right. Now,
got you covered.
court's going to, is a bond being requested?
It is, Your Honor, and the my client in filling out his application has just been hired on at Tyson's and starts work on Monday. He does have longtime residents and family here, and obviously there is some communication with this officer because the officer told him to come over here. He did, and he was directed here knowing he was going to be arrested. In light of that, Your Honor, we'd ask that he be released with a condition of his bond that he continue to report and stay in contact with his officer, and that he maintain his employment and get on track with them until his next court appearance on June 26th. I think it says a lot that he voluntarily came over here and followed her direction and turned himself in.
Judge, I prefer a $4,900 cash bond because it appears that most of the violations are not honoring his obligations to the court.
Well, Judge, since he filled out an affidavit and specifically informed the court that he starts a brand new job at Tyson's at $10.50 an hour on Monday, I seriously doubt my client has that much money. And if the state wants their money, obviously he's going to have to work.
Court's going to set a bond. Again, I think Mr. Carter's argument is well made in terms of, you know, that would be the ideal situation, but the reality is probably doesn't have that kind of money. But court's going to set a bond at $2,500 cash or surety, and he will be directed to continue, as a condition of that bond, continue to report to his probation officer and comply with the requirements of probation. That will be the order of the court.